Hopefully you can hear me pretty well. But I'm Amanda C. I'm a family court judge in Hardy, Grant, and Pendleton counties. I'm one judge in 3-county area. This is different, as you know, across the state. Some places have 1 county and 5 judges, or 2 judges in 1 county. Both 2 judges in 2 counties. So when that asked me to speak about issues with interactions between family court and circuit court, it's sort of hard to tailor something that would work for the entire group because it is so individual across the state. I don't know if there was anything in your materials, but I wanted you to get some cheat sheets and start out with residency issues and venue issues, because as you know, and those of you that have been doing it for a really long time, especially with family court, these people get themselves into some serious messes. You cannot dream these facts up, and it always starts with residency, whether they got it or which county are they to file in, and of course, depending on which proceeding, whether it's domestic violence or it's divorce or custodial allocation, it's really different. I wanted to hit the highlight really with the divorce residency requirement. If they were married in the state of West Virginia, they don't have to be here the entire year, they just have to be a resident. If they were married anywhere else, they have to have that continuous 1-year residency. And so I just wanted to point that out real quick, and I put that in just as a quick reference in your materials. If the marriage, I guess sometimes you'll see the plea and it'll have an adultery ground in it from time to time, maybe more often than not. I'm not sure. I once had a filing where the ground was she has 23 cats and I just can't take it anymore. I don't know if that's pulling in human treatment, if maybe you're reconcilable differences, I don't know. But that's the point. Really we don't run into that little nuance in the residency statute about the adultery ground, because if it's a pro se litigant, they use the pro se packet most of the time, and it automatically alleges as an alternative ground to reconcilable differences. So most of the time you're able to ignore it. With venue, and that's the county where it's filed, if the respondent lives in the state of West Virginia, the petitioner has 2 options. They can file it in the place that they last cohabited together. Of course, there's a whole ball of wax. Generally, you'll have lots of different facts as to, or disagreements as to whether they cohabited together, when that was, what is cohabiting versus separating from Bedford, living in the same house. But if they've cohabited, they can bring it in the place where they last cohabited together, or they can bring it in the county where the respondent resides. Now, if the respondent lives out of state, the petitioner has the option of bringing it, again, in where they last cohabited together, or in the county where they reside. And so there are service issues that go along with that. Custodial allocations that don't involve divorce are a little bit different because of the residency requirement. The child has to live in the state of West Virginia for at least 6 months. And there's an interesting, I guess it's a forum shopping issue that you may run into with litigants that don't want to bring their action in one place for one reason or another. Actually, the child does it for an emergency temporary order, and if it's an emergency situation, if they are a resident for 1 day and it's an emergency, that family court judge can enter a temporary order and sort it out and then send it back for finality wherever it's supposed to go. So with that said, I can switch to communications with the public, but I wanted to say, if when in doubt, just let them file it and we'll sort out the mess, because as you know, you're only hearing one side, and usually if it's pro se, they want to talk to you about it and tell you while they stand at your window everything that's gone on in their life since the day they met this person, or the day that, and I understand that it must be awful. I'm insulated as a judge. When I was practicing, when I was doing private practice and practicing law and domestic relations, I thought, every Sunday night I expected to get a call about somebody that dropped someone off on time or whatever. So I totally understand that it gets to be a sticky wicket and it's hard to kind of shut them off and say, here's what you need to fill out. You don't really want to hear this, it's really up to them. So if when in doubt and you're not really sure about residency or venue, just let them file it and we'll figure it out and send them packing where they need to go if it doesn't belong there. Communication with the public is interesting, and I was talking a little bit about it with some folks prior to starting the talk. It's hard not to give legal advice, and especially in small places, and especially with people that you are familiar with, family members. I call it my free legal advice tour when I go to Walmart, and I know you do that too. You're at the gas station and someone walks up to you with a cup, or you're in the restaurant. I hate to bother you, but, well, you bills, so what's the question? And a lot of times you just want to say, well, tell you this, and especially with people you're familiar with or family members, resist the temptation. Because my dad always says, no matter, there's always two sides, no matter how flat the pancake, and you're only hearing one side. But, for example, they'll come in and they'll say, what do you think? He's never seen the child, or she's never seen the child, and she's telling me she's going to take me to court, and I think I'm going to file, and I need this, and what do you think the judge is going to give me custody? And no matter how well you know your judge, or how well you know what they didn't tell you, is what you have to be worried about. Like, oh, by the way, I'm living with a registered sex offender, or something of that nature. And they won't volunteer that information. So anytime you feel even the most benign issues, just avoid it, because you have no idea what they're not. It's not what they tell you; it's what they don't tell you. 9 times out of 10, it's going to get in trouble. The other thing too about is recommending lawyers, or they'll say, well, who do you recommend? Or who should I see? Or the judge has ordered me to some kind of psychological evaluation. Where should I go? Or who should I see? Try to avoid that as well, because if you recommend a lawyer and that lawyer, for whatever reason, doesn't get the outcome they want, which in family court is 10 times out of 10, because no matter what the judge does, nobody's ever happy generally. So they're unhappy with their lawyer, they're unhappy with the judge, they're unhappy with themselves, they're unhappy with the other side. Just avoid that as well. What I've done now, and I haven't given it to the clerk's office, maybe I have, maybe Sarah did, my case coordinator. If you feel like you don't want to shove them off somewhere else, or you feel like you're not providing a service to them when they're asking you, or they seem frustrated, we were not too long ago our offices were asked to compile a list of resources, attorneys, their contact information, legal aid, domestic violence shelters, family preservation offices, visitation offices, places like that. So just a list of resources. And we compiled all those. We were required to have those so that I guess our family court coordinator could see exactly where the needs were, or what we were ordering and that sort of thing. If you ask, they will provide you, and I don't know if we have provided it, but I'm going to, and while we're getting ready for this, I thought about it. If you don't want to if you feel bad about not giving legal, but you keep telling them I can't give you legal advice, and they don't understand, because they just don't know anything about it, and they're frustrated, hand them the resource list sheet, because they don't walk away empty-handed. It has everything that they really need on it, and you feel a lot better about the interaction as a whole, and haven't done anything to violate the ethical rules.
Was each family court judge asked to do that?
I was under the understanding, because I got an email that asked us to do it, so I did it.
Of course.
Yes, you did. I bet. So I did it, and we had them down there. We have them laying in our conference rooms out there. But when I was getting ready for this, I thought, what a great resource to give the circuit clerk's offices, because while they're in there telling you every detail of their life and all this, you can just be giving them every service they need to address every problem that the other person has caused them. So I thought that would be helpful. All offices are different depending upon the custom of your office. Smaller places, perhaps, that don't have as busy a docket as perhaps these bigger places. I don't know that anybody does this. At least not in our area, but I don't know that anyone does this, but I did want to touch on it. Closures at lunch. If you close your office at lunch, and especially if family court's going on, sometimes we'll order bonds to be signed into guardianships, or someone's going to want to post a bond for they've been found in contempt and they don't want to be hauled to the regional jail there in the next few minutes. Closures of offices sometimes cause headaches. It's up to you, but in the spirit of public serving, which is what business we're all in at this point, just keep that in mind. Convenience for the litigants, especially over the lunch hour, because a lot of times that's when they're able to get things done, or that's what's keeping them from going to the regional jail.
Close our office.
Okay, I didn't know if that happened, but if it did, I was just going to point that it doesn't in my area. Communication with judges' offices and staff. I think we have a really good relationship with the clerk's offices that I work with. I'm given to understand that that's the case across the state. I polled our association, I'm president of our judicial association, and I polled our association before coming here and preparing for this. And I didn't get much feedback because everybody appears to be very happy with what's going on with their clerks. offices. There were some, it's important to communicate about all aspects. Like I said, it's different. Every judge likes it done differently. Obviously, we don't have a monopoly on great ideas, so I always look for input from the clerk's offices to help us move cases and make the transition from filing to scheduling. You may keep schedules, some of you may keep schedules for your judges, other offices schedule their own stuff and tell you, you just get notices of hearings to file, but multi-judge versus single judge versus single county versus multi-county circuits, it's going to differ all across the way. So I always appreciate feedback from our clerk's offices. My staff always appreciates it. Bless you. And so just keep the lines of communication open because we work together on this. It's a partnership, and family court in particular deals with the big three, love, money, and kids, and can't get any more inflamed than that. So as long as we keep the dockets moving efficiently, everybody, we can get them out of their misery and the light at the end of the tunnel a lot quicker. Please, 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 if someone is rude to you upstairs or your staff at the filing phase, or if they're up there, posting a bond because they're mad about what just happened in family court, let us know. I can hold them in contempt. Your judge can hold them in contempt. They can drag them back down, make them apologize, make them post a bond, be nice, and it doesn't get released until the case is over. And if it's just, please let us know. You don't need to be mistreated at all. Wow. This is public service, and public servants and people in the service industry are treated so horribly. You know this from working there. They expect better service than they get at home. I cannot figure it out. And so we don't want you to feel like you're being beat up. And people are inflamed at this time in their lives in family court, and they're likely to take it out on the first person they see, which is the circuit cover's office. So let us know, and we will make sure that we handle that. And our association wanted me to make sure that I convey that message to you, because nobody should have to put up with rude people when you're just trying to do something for them and improve the problem that they're having. I told the association, as I said, just nuts and bolts concerns. If your judge asks you to just check, so a lot of times we'll get frequent flyers. We know that 20% of the people take up 80% of our documents. Double check, a quick computer check can keep the same family and same kids from 2 different filing numbers, and that's just a quick check. That's all you have to do. Sometimes it gets past you. There's a really quick, easy way to fix it. I just do a consolidation order and shove it all back into the original filing. That's okay too. But if you do it, it's not so bad in single judge circuits as it is in multi-judge circuits. Because one judge will end up hearing, there's no check, and one judge hears the child support issues, and one judge hears the custodial allocation issues, then the other judge hears the divorce issue. And to consolidate that, make sure that one judge hears all issues, much more efficient. It's easier for the parties, and it's easier for the judge, actually. So just trying to make it as efficient as possible for everybody involved, including your office, because then you don't have as much, it's not as much people, much less numbers. Or when pro se litigants file, a lot of times we'll have a Bureau for Child Support Enforcement case that's been filed. Usually the mom and dad are unmarried, one of them gets a service or some type of benefit from the state, it's a mandatory referral. They file, Bureau for Child Support Enforcement files on behalf of the state of West Virginia to get child support established. Then they get that notice of hearing in the mail, and they blame the other person for bringing it. And it's actually the state, they have to know it's mandatory. They don't know that. So they get mad at each other, and then they start fighting for custody. And they file that separately. Make sure that if you do a double check, we can hear that all at one time, or and that way you don't have to file it back into the other meetings. I always try to head that off. If we're in BCS, if they haven't filed anything else, and we have filed we've got a BCS case, I ask them, if it sounds like it's going to be a brouhaha, I handle the bureau case, dismiss them out, and then continue it and bring those people back for another day so that they don't, the bureau doesn't have to sit and listen to all of the terrible things that this other person has done, what a horrible father or mother they are. And then the other thing was all infant guardianship proceedings that involve multiple children with different fathers or mothers. Like, let's say Fisher grandma comes in and files, and she's got 3 kids, and her daughter has 3 kids. So you've got a mother, and then there's all 3 different fathers. They all need different case numbers. I didn't know that. That's why I brought it up. I just started doing that. So I just wanted to remind everyone that In this day and age, we've got lots of half siblings running around, and auntie or grandma or grandpa or uncle are stepping up and taking care of them, thank goodness, but we've got to have different kids. You can hear them all at one time, but you just have to have different case numbers. And P.S. I did learn that there are 20 new, forms are coming back out. They've revamped some forms, not the DD forms, but I want to give you a heads up that over the next few months, about 20 of the domestic filing forms are going to be, they've been changed and they're going to be rolling them out here over the next few months. We appreciate everything you do. I have practiced law 8 years before I took the bench, and I've practiced in Mineral County, Hampshire County, Hardy, Grant, and Pendleton counties. And the clerk's offices were always good to me when I first started practicing. They told me what to do, what to file, where to go, who you can trust, who you can't trust, where to park, that sort of thing. I've always had a great deal of respect for the circuit clerks, and have actually used them all as therapists before and after court. I appreciate it, and I do it now with not so much with the Hardy County, because their office, unfortunately, is on the second floor, and we're in the basement. I don't get to see them as much. But I share the circuit courtrooms in Grant and Pendleton County, and so I get to see the clerk's offices right there. And after court, sometimes, because you can't bring this up, I come out and they all ask, how's it going in there? And I'll say, oh, you will never believe it. So then you can just we use you as a sounding board. We really appreciate everything you do. I wanted to end with this one story. It's a Grant County case. It was a long day. I don't know if it was a full moon or all the nuts and squirrels are out. It was crazy. And I was in there calculating child support for a gal, and she had a child by the man that was in the room, and she had a younger child by a different father. And we were calculating the formula, and I said, well, I'm going to give her credit for having another legal dependent in the household for purposes of the formula. I don't know if she wasn't listening or I wasn't listening at that point, but she pipes up and she says, can I ask a question, Judge? I don't understand why he has to pay for my younger kid's formula because his kid drinks regular milk now. I don't know what to say at this point. I'm thinking like, did I have to work correctly? I've been down for too long here at this point. But it's always nice to be able to come out, and we really appreciate everything you do, not just our record keeping, but just listening to the stories and let us kind of debrief and use you as a sounding board. It's funny, the next day I had another bureau day in a different county, and of course it had spread like wildfire around their office, and they came in and said, Judge, we just wanted to know which formula you'd be using today, Similac or Infamil. I appreciate everything. Nancy and Cheryl, Libby in Grant County, and then I got Kim and Deb and Kelly down in Hardy County, and then Susie and Shaylee. I didn't see them here. Shaylee and Susie and Heather. You all are wonderful. Thank you so much for helping me every day. You keep it moving for us, and we just really appreciate it. Thank you very much. Have a great conference.